Get ready. 5 seconds. Start. On the perusal of the reply filed by the respondent number 1, the owner, and respondent number 2, the driver of the vehicle in question, it is clear that they have not denied the involvement of the vehicle in question in the accident at the relevant date and time, and it is also not denied that the petitioner was not traveling in the vehicle who sustained injuries as a result of the accident stop. However, their plea is that the accident was not the result of rash and negligent driving of the vehicle in question by the respondent number 2, but it was the result of some mechanical defect which developed in the vehicle in question stop. On the other hand, it is the plea of the petitioner that the accident took place due to rash and negligent driving of the vehicle in question by its driver stop. Para. In order to prove this plea, the petitioner has stepped into witness box as PW1 and has tendered in evidence his affidavit exhibit PW1/A, in which he has stated that the cause of the accident was the result of rash and negligent driving of the vehicle in question by its driver, in which he has sustained injuries stop. He was cross-examined on behalf of the respondents, but nothing contrary could be elicited in his cross-examination so as to discredit his testimony stop. He has denied that the accident was not the result of rash and negligent driving of the vehicle in question by its driver stop. Para. In order to rebut the aforesaid evidence of the petitioner, the respondent number 2, Sohan Lal, has stepped into witness box as RW1 and has stated that the accident was the result of developing of some mechanical defect in the vehicle, due to which steering of the vehicle discontinued to function, resulting into accident stop. However, it is to be noted that such statement of respondent number 2, the driver, has not been corroborated/supported by any other material on record stop. The respondent has not placed on record any mechanical report nor has examined the mechanic to prove that there was any mechanical defect in the vehicle which resulted into accident at the relevant date and time, and no other witness has also been examined by the respondent to prove their plea stop. Thus, in the absence of corroboration from any mechanical report, the statement of respondent number 2 that the accident was the result of mechanical defect in the vehicle in question cannot be relied upon, and the same cannot be considered to be sufficient to establish the plea of the respondent. Stop. Para does, in view of what has been stated above, it can be safely concluded that the cause of the accident was the result of rash and negligent driving of the vehicle in question by respondent number 2. Stop. Para, as already observed, that the respondents have not denied that the petitioner was not travelling in the vehicle in question at the time of accident, and he has sustained injuries as a result of accident, and even his statement on oath, the respondent number 2 has nowhere denied such facts. Stop. Para, the petitioner, while appearing as PW1, has stated that he sustained injuries as a result of accident, due to which he remained admitted to the hospital at Mohali from 16/12/2009 to 28/12/2009, as he had sustained fracture of the ribs, and such statement of the petitioner is corroborated by Vinod Kumar, who is son of the petitioner. Stop. B. It stated that both of them have not been cross-examined on behalf of the respondent on the aforesaid point, and as such their testimonies have gone unchallenged on the aforesaid point, as well as unrebutted, as there is nothing to the contrary. Stop. Para, in the instant case, though it is the plea of the petitioner that he has sustained permanent disability as a result of the accident, due to which he has been rendered incapable of doing any work, but such plea of the petitioner has not been supported / corroborated by any material on record. Stop. Even the petitioner, while appearing as PW1, has nowhere stated that he had suffered any permanent disability as a result of accident, and there is also nothing in the statement of Dr. Vikas Singh, PW3, to infer that the injuries sustained by the petitioner has resulted into permanent disability to the petitioner. Stop. Thus, in view of this, the plea of the petitioner that he has sustained permanent disability as a result of accident cannot be held to have been established on record, and consequently the petitioner cannot be held to have suffered any loss of future income. Stop.